then he lost his temper.
It's potentially dangerous. Most county courts are sort of rather small, insignificant buildings. So what you have is in a small hallway, you will have a very nervous applicant and quite possibly an extremely irked and aggressive respondent who hasn't liked the fact he's been served with court papers, hasn't liked the fact he's been dragged to court, doesn't like having read a statement alleging that he's been assaulting his wife or his partner. If you've got lawyers on both sides, there is at least there are intermediaries that prevent the two people having to speak directly to each other, both outside court and inside court. But more than that, lawyers are actually able to take their client's instructions, go to their opponent and say, well, my client is denying this, but he accepts that. In a lot of domestic violence cases, they end up with an agreement, and the respondent will give undertakings not to do, that is to leave the matrimonial home, not to go within 50 yards of his ex-wife, not to go to her place of work, not to go to the children's school without written permission, and so on. And that's something that, for a litigant in person, it's very difficult to negotiate directly with the other side, but it's something that, it's bread and butter to lawyers.
It's unusual for judges to speak out publicly, but last week Sir James Munby, the President of the Family Division of the High Court, became the most senior of several judges who have recently condemned the injustice of the cuts to legal aid for family law cases. Would you like to have representation in court when you're going for these things?
Yeah, definitely. I think it would make it a lot easier, a lot less stressful. And I was really shocked because I can't afford it, and it's not like I was going for this order for the fun of it. It's, it's not wasting anybody's time. It's something that I really needed, and it's for my safety. And the only way I could afford it would be put myself in debt.
You're bringing a judicial review to challenge the restrictions to the availability of legal aid. What are you going to be arguing?
The heart of our case is that the regulations that set out this evidence criteria are unlawful because they don't reflect the definition of domestic violence which is in the Legal Aid Act, which sets out the new scheme, and they simply don't reflect the government's commitment to ending violence against women and girls and to protecting women and girls from violence.
I don't think my ex-partner's ever going to be any different towards me. I'm hoping the order will make him think twice about his actions towards me. When the order runs out, I'm hoping there won't be anything, but if there is, then I'll just have to go for it again. But I just want peace of mind, and I just want to be able to live my life without being in fear all the time.